Last speaker for today is Professor Casey Johnson, who is a history professor at Brooklyn College and the City University of New York Graduate Center. Professor Johnson holds his BA from Harvard, his master's from Chicago, and his PhD from Harvard. He's held a series of teaching and faculty appointments, but he is perhaps best known of all for his work on the internet on a variety of subjects. Most recently, his blog Durham in Wonderland, and a book that he co-authored with Stuart Taylor, Until Proven Innocent, Political Correctness and the Shameful Injustice of the Duke Lacrosse Case. It's an excellent book, and I commend it to all of you. Professor Johnson was good enough to, after writing this book, Professor Johnson proceeded to flee the country to Israel, but he was good enough to fly back to talk to us a little bit about the Duke Lacrosse case and the Academy. Professor Johnson.
Thank you very much for the kind words. Thank you all for coming. I realize that the last talk of the day can sometimes be a small crowd, so I'm very much appreciative of your attendance. In some ways, the Duke Lacrosse case was a very simple story. It was the story of a woman named Crystal Mangum, who not only gave a number of contradictory stories, but in fact never told anything close to the same story twice in her interviews with law enforcement. At various points in the case, she claimed that 0, 2, 3, 4, 5, and 20 people raped her. Her final story was that the rape occurred while she was levitating in the captain's bathroom. Some stories claimed that there was no physical assault beyond the rape. In other stories, she claimed that she was beaten on the head on the sink during the attack. In other stories, she said that she was assaulted physically by 10 other lacrosse players, which left a grand total of an injury of a non-bleeding scratch on her knee. And in her treatment of the second dancer, in some stories, the second dancer was an accomplice to the rape. In other stories, she was a neutral witness, and then still in other stories, she was a fellow victim, having been raped by 3 additional and never revealed lacrosse players. So if you were attempting to imagine a non-credible witness, it would have been harder to come up with someone less credible than Mangum. And then the district attorney, or the former district attorney, Mr. Nifong, down 17 points in the polls 6 weeks before a primary that was about to lead to his defeat, then proceeded to attempt, in retrospect, to violate as many procedures as he possibly could in one case, beginning by making a series of inflammatory public statements that would have been unethical even if they were true. They were false. Followed by ordering the police to run a third lineup after the first 2 lineups didn't produce the desired result, but making sure that the police only showed Mangum's suspects in this third lineup, refusing to meet with defense attorneys who said, and actually did, possess evidence of absolute innocence of their clients, meeting with the lab director and coming up with an agreement to withhold, for the lab director to withhold exculpatory evidence in his report, namely that there were DNA of between 4 and 9 males on Mangum's rape kit, unidentified, not lacrosse players. And then finally lying to not 1 but 2 judges about the content of his conversations with this lab director. So again, if one would assume that an environment of people who are concerned with false accusations and prosecutors running amok with false accusations would be the contemporary academy. And so in a normal circumstance, you would have assumed that this would have generated tremendous outrage from the faculty at Duke. As we all know, this did not occur. Well, it did generate a tremendous outrage, but it generated tremendous outrage on Nifong's behalf producing what appears at least to have been a first in American history, a situation in which the statements and actions of their own professors were cited as one of the major reasons why college students could not receive a fair trial in the local jurisdiction, a fact for which Duke, one would think, would be ashamed, but there is no evidence that they are. My talk today is going to talk a little bit about the academic aspects of the case, but I'd be happy to take questions about the other aspects of the case as well over the course of the blog and the book. I did develop a fairly good working relationship with members of the defense side. There are, I think, three reasons why this case is important for all of us who are concerned about the nature of the academy, beyond the simple human factor of an instance where you had college students who were targeted deliberately because they were college students. This was the fact that they were students that made them politically useful for Nifong, and then saw their own professors betray them, a human story which is really unfortunate. The first was an almost gleeful willingness to abandon what we think of as the Academy's willingness to uphold due process. Certainly if you read statements of the American Association of University Professors since the McCarthy era, we hear constant references that it's a special element of academic affairs to stand up for procedural regularity. This was not done, and instead the vocal element of the Duke faculty decided that they would use the Lacrosse case to advance their own personal agendas or curricular agendas or transformational agendas for the university. In retrospect, they picked the wrong case to exploit, but at the time it seemed like a relatively safe bet. The highest profile example of this was an ad which was published on April 6th of last year. It was rushed into production. It was funded by the African American Studies program. It came out of the Duke budget. This violated Duke procedures. The author of the ad, Wanima Lubiana, was quite clear that she wanted the ad out quickly. There was a fear that the DNA tests, the first round of DNA tests, which Nifong had publicly promised would identify the guilty but also exonerate the innocent, there was a fear that these results might come back. The Lacrosse players' attorneys had promised that there would be no DNA matches. There would be no case to exploit, presumably, so the African American Studies program wanted the ad published. It was published in the Duke Chronicle, the campus newspaper, but was then also hosted for 123 days on the homepage, departmental homepage of the African American Studies program at Duke. Another violation of Duke procedures. The administration never forced them to take it down. They only took it down after they started getting criticism from extraneous bloggers and then tried to sort of remove the evidence. This ad stated that something, unequivocally stated that something happened to Mangum. It committed the signatories, 88 of them, to turning up the volume regardless of what the court case described. It said it gave a thank you to protesters, and not just a thank you, but a thank you for not waiting. The two highest profile protests on campus before the ad came out were a protest in front of the Lacrosse players' house, where a group that called itself the Pot Bangers, because they banged pots and pans, carried a huge banner that said castrate, and then a Take Back the Night march on March 29th, where feminist activists spread around the campus huge wanted posters with the Lacrosse players' photographs on them. No Duke professor who signed the statement has ever given a reason why it was so important, not just to thank these protesters, but to thank them for not waiting. And finally, the ad claimed, in what was a really unprecedented event, to have the official endorsement of 5 academic departments at Duke and 10 academic programs. It turns out that in the case of at least the 5 academic departments, none of these departments ever voted on whether or not to endorse the ad, and there was not a majority of any of the 5 departments that allegedly endorsed the ad that actually supported it. Around a year later, the provost of Duke, Peter Lang, sent around a missive conceding that procedures had not been followed, and in fact, none of these departments did actually endorse the ad. Some of the group members, group of 88 members, went even further. A professor of English, Houston Baker, around 2 weeks after the case first broke, issued a public letter demanding the immediate expulsion of at least 46 of the lacrosse players. There was one African-American lacrosse player. Baker was never quite clear on whether he too should be expelled or not, but the reading of his letter suggested that he too had to be expelled. The former dean of the Duke faculty, William Chafe, spent 11 years as the faculty, a distinguished historian of the civil rights movement in the United States, published an op-ed in the Duke Chronicle, again before there were any indictments, asserting that the behavior of the whites in Mississippi who kidnapped, beat, and murdered Emmett Till provided the appropriate historical context through which to interpret the behavior of the Duke lacrosse team. And in an unintentional commentary of the intellectual seriousness of Chafe's efforts, this leading historian of the American civil rights movement misidentified the year of Till's murder. And several Duke professors chose to use class time to comment on the guilt of their own students, including a history professor named Reeve Houston, who on March the 27th, that was 3 days after the case first attracted any publicity, set aside his scheduled lecture and announced that he was going to share with his class the subjects of his research, which had told him that not only had a rape occurred, but that there was an ejaculation in the rape. Houston has never said what research he did between March the 24th and the 27th that determined this information. Who were these faculty, this group of 88? This was not a random cross-sampling of the Duke campus. 80% of the professors in the African American Studies Department signed the statement. 72.3% of the professors in the Women's Studies program signed the statement. 60% of the professors in the Cultural Anthropology program signed the statement. Large numbers of history, English, and literature professors signed the statement. There was only one law professor who signed the statement, and she did not have a full-time appointment in the law school, and only 3 math or science professors who signed the statement. So a statement that skewed towards the humanities, and especially towards humanities at Duke, that over the last 15 years had been extremely aggressive at implementing what the administration termed a diversity program of hiring. 85% of the signatories to the statement described their research interests as race, class, or gender, and in some cases all 3. And in some cases in what would be a kind of caricature of tenured radicals on contemporary campuses. The author of the statement was this literature professor named Wanima Lubiano. In February of 2007, she gave an interview stating in what was the Pauline Kael moment of the Duke lacrosse case, saying, and I'm quoting here, "In the moment when the ad came out, I did not hear from even one colleague that there was something wrong with the ad." Lubiano was an interesting figure. She had received tenure at Duke in 1997 on the basis of 2 books that were listed as forthcoming, one from NYU Press, one from Verso Press. In the year 2008, neither of those books have appeared, and the websites of both presses give no indication that the books are going to appear anytime soon. Another group signatory was a literature professor named Grant Fared, whose most recent publication had been a book that described Houston Rocket Center Yao Ming as the greatest threat that currently exists to the American empire, something that undoubtedly made Osama bin Laden feel very nice. Fared was recently hired and promoted to full professor by Cornell, and the head of the Cornell English department, a woman named Molly Haidt, whose most recent book was called Class Porn, announced that the entire department had always thought very highly of Fared's scholarship. And a women's studies professor, a signatory to the statement named Kathy Rudy, published an essay in the early 90s saying that she had initially entered higher education because it gave her an opportunity to explore, and I'm quoting here, the idea that women were superior and that a new world could be built on that superiority. Rudy is now working on a critique of animal rights from what she calls the speciesist perspective, which is a claim that animal rights activists discriminate against animals by prioritizing humans over animals. It's a critique of animal rights from the far left, which is not easy to do. So this was effectively a group of people whose ideas were quite extreme, and oftentimes the criticism of the academy is that professors bring their politics into the classroom. What we really saw at Duke was professors who brought their pedagogies into the political arena. It was really quite the reverse. Secondly, in terms of the academic experience and broader lessons, is that we like to think of professors as endorsing the dispassionate evaluation of evidence and at least being open to facts. What was striking about the Duke Lacrosse case in terms of the behavior of the Duke faculty was the utter closed-mindedness of the faculty who had rushed to judgment, and indeed to the good portion of the Duke faculty who did not, that increasingly defended them, and to the Duke administration. Even as Nifong's case collapsed, and it was beginning to collapse as early as May of 2006, and it was quite clearly collapsing by last fall, the faculty activists who had gone after the lacrosse players maintained that they had performed correctly. A history professor named Peter Wood gave an interview to The New Yorker last summer, stating that lacrosse players in his class had advocated genocide against Native Americans. His evidence for this: one student in one of his classes had given an anonymous student evaluation, as occurs at the end of any term, and given a joking reference to genocide against the Indians. There were 10 lacrosse players in this class. There were also 55 non-lacrosse players. Wood gave no reason to believe that this statement came from a lacrosse player. In fact, I found out that it did not come from a lacrosse player. Grant Fared, the same guy who now has moved to Cornell, published an op-ed, the last public statement of any Duke professor before the November election in Durham, which Nifong won, accusing hundreds of Duke students of what he called secret racism. Their offense: they had the temerity to register to vote in Durham, an act that Fared argued suggested a disregard for black women's bodies and an endorsement of what he termed the arrogant sexual prowess of the men's lacrosse team. This voter registration drive was organized by 4 female Duke undergraduates. Fared never quite explained how this was so. In January of 2007, African-American Studies and English and Law professor Carla Holloway released what turned out to be fifth-hand, unsubstantiated gossip that there was a secret witness in the lacrosse case that would show that there were racial slurs at the party throughout, which was one of the key areas of dispute. Roughly, a year later, this secret witness remains secret, and I suspect the secret witness will remain secret for the rest of Carla Holloway's life. And then there was a kind of Orwellian attempt to rework the past that was originated in a January of 2007 op-ed by a former Duke dean and English professor named Kathy Davidson. Davidson admitted in emails that were later forwarded around and which I obtained that part of the reason for her op-ed was that she had consulted a lawyer. And the lawyer had told her that she and the other 87 members of the group could very well be subject to defamation suits from the lacrosse players. So she publishes this op-ed trying to rewrite history of the spring of 2006. Her claim was that the statement was justified. This was a statement that was originated in late March and early April of 2006, roughly 1 week after the Duke lacrosse case first went public in the media. Try to think back what the media attitude was at that time, what the attitude on campus was at that time. Davidson's contention was that the statement was necessary because during that week period, the only voices that were being heard were the voices of the lacrosse players. That minority students on the Duke campus were being angrily harassed because they dared to imply that the lacrosse players were guilty. Well, it turns out that there was harassment on the Duke campus in the week or so before the ad. The people who were being harassed were the lacrosse players. One lacrosse player was actually surrounded on campus, and people screamed at him to confess. There was the castrate banner. There was the in-class harassment. Meanwhile, African-American students received sort of very favorable treatment from the administration. The president, the provost, the dean of undergraduate education all met with delegations to express their concern and their support for minority students on campus. Davidson was asked to give evidence as to how it was that in late March and early April of 2006, it was the lacrosse players' voices who were being heard rather than the voices of their critics. She, at that time, announced that she would no longer be commenting on the lacrosse case at the advice of her counsel. And then a few weeks later, in early February of 2007, 89 Duke professors issued yet another statement that was signed by around 55 of the original group of 88. Many of them had left Duke, and a few chose not to sign. And incredibly, 24 professors who had not signed the original statement came together and signed this new statement, which completely reaffirmed the group of 88's statement. This was a statement given in February of 2007. By this point, Nifong had been removed from the case. The State Bar had filed ethics charges against him. It was clear to anyone with half a brain that this was a complete fraud. And the killer line from this letter, this was called the clarifying letter, was a statement that, in fact, the signatories to the group of 88 said did not want to thank all protesters. They only wanted to thank protesters who had said that their stated aim of the protest was to combat racial and gender violence. That was the stated aim of the potbangers protest and the wanted protesters. How, 10 months after the fact, these people could be thanked again was really quite astonishing. Even now, there's been no indication of any reconsideration on the part of the signatories. The president of Duke, Richard Broadhead, after defending the Group of 88 statement for much of 2007, issued a very limited apology in September, in which he conceded that there were faculty statements that were, he termed it, ill-judged and divisive. But he said that there would be no reason to examine why the faculty had made such statements, that it was more important that everyone move on. And then finally, in terms of the academic side of the case, what was quite striking and what remains quite striking is the support for the Group of 88 and their allies, and to a certain extent from support for the Duke administration from other quarters of the academy. This case was described by Lane Williamson, who was the chair of the disciplinary panel that disbarred Nifong, as a fiasco, and it's a pretty good description of it. And at the very least, you could argue that one of the good things that came out of the Lacrosse case was a reconsideration of prosecutorial misconduct by, I think, many elements within the legal community. Some journalists, maybe not from the New York Times, but from other papers, have, I think, reconsidered how they cover high-profile criminal cases. You could look at the coverage of the Michael Vick case. Vick was, as we all know, turned out to be guilty, but nonetheless, there was a much more restrained attitude, I think, in terms of press coverage as a result of the Lacrosse case. And there's been some willingness to ask hard questions on the part of journalists. The American Journalism Review did a very substantial piece on the media's mishandling of the case this past summer. There's been almost no such critical self-reflection among higher education, not just at Duke, but elsewhere, as to how it could be that in the highest profile case of prosecutorial misconduct in, the last decade at least, so many Duke professors could have gotten the case so wrong. Instead, there's really been the reverse. In the summer of 2006, 15 African-American studies professors, prominent professors from around the country, professors at NYU, at Penn, at Columbia, issued a public letter defending the performance in the case of Houston Baker. Baker, remember, was the Duke professor who had demanded the immediate expulsion of all of the lacrosse players. By this point, he had done a number of other things. He had emailed one Duke alumnus stating that he had no doubt that even if the rape hadn't occurred in this instance, that lacrosse players had raped black women in other instances. And he had emailed the mother of a lacrosse player who had criticized him for such statements and called her the mother of a farm animal. These 15 African American studies professors in their public letter praised Baker, defended him against his critics, and argued that Duke needed to recognize, and the Academy needed to recognize, that the Duke lacrosse case was a teachable moment. How was it a teachable moment? It was a time, and I'm quoting here, to recognize that the academics and departments that most assiduously impart the best ethical and intellectual wisdom of their disciplines are always race, class, and gender inflected. How you could teach this by the summer of 2006 seemed not clear. In the immediate aftermath of the exoneration last April, history professor named Claire Potter, a host of the wonderfully named blog Tenured Radical, a figure of some significance within the historical community, gave her reflections on the case. The villains were, again, the people who had criticized the group of 88. She denounced, and I'm quoting here, those nitwits down at Duke who have been wearing the innocent bracelets. Of course, the players were innocent by this point. She described the lacrosse team as a, and I'm quoting again, a semi-criminal youth gang. She asserted that the dancers were, it is clear, physically, if not perhaps sexually assaulted. And over the last several months, she has refused to provide what proof she had that the dancers were clearly physically assaulted. And she concluded by musing, and I'm quoting again, "Do we think that women have not been raped at other Duke lacrosse team parties?" So this incredible unwillingness to ask how it is that the Duke faculty could have gotten this so wrong. And indeed, what's happened in the case is that many of the most outrageous voices from the faculty at Duke have been rewarded. Houston Baker was hired away from Duke by Vanderbilt, which gave him an endowed chair and a year and a half off from teaching. Some could argue that that might be a good thing. Charles Payne, who was the chairman of the African American Studies program, who authorized the use of departmental funds for the ad, was hired away by the University of Chicago, again with an endowed chair. Grant Fared was hired away from Duke by Cornell with a tenured full professorship. There's been no suggestion at Duke that the faculty members have suffered any consequences. Indeed, one of the group of 88 members who berated lacrosse players in her class in the immediate aftermath of the publication of the case was promoted and named Dean of Social Sciences of the faculty. She has quite unsurprisingly refused to authorize an investigation of faculty in-class behavior. Her refusal to authorize this investigation is one reason why it appears Duke might be getting a lawsuit from the 43 unindicted lacrosse players who were victimized in other sorts of ways. In a lot of ways, the lacrosse case was, if you want to borrow a term from mathematicians, an existence proof. There's a general sense that the academy, especially the undergraduate academy, has become obsessed with issues of race, class, and gender, has ideas that sort of fall out of the extreme. And we have some superficial examples of this that pop up in the media all the time. The Ward Churchill case from Colorado. The Tim Shortell case from my home campus, Brooklyn College. Shortell was the sociology department chairman who was elected after he had written that all religious people were moral retards and that Karl Rove was the American equivalent of Joseph Goebbels. He was subsequently removed as chair, but only because of protests from Brooklyn alumni. But it's very difficult to get a firm sense of how pervasive the problem is within the academy. In the Duke case, though, you have what is widely acknowledged to be one of the 10 best undergraduate institutions in the country, and a faculty that witnessed what was the highest profile case of prosecutorial misconduct in recent times. And yet, for 6 months, not one of the nearly 600 members of the arts and sciences faculty publicly criticized Nifong's behavior, publicly criticized the group of 88 for rush to judgment. And when the first one did, a chemistry professor named Steve Baldwin The next day, he was greeted by a letter in the Duke Chronicle accusing him of using the language of lynching. This came from the head of the Women's Studies program. And the head of the Center for the Study of Race and Ethnicity on the campus sent him an email inviting him to come to his office where they could settle their disputes violently. It's very hard to suggest that what occurred at Duke is anything particularly unusual, and I would argue, in fact, that it's not. The only thing that is somewhat unusual about Duke is that Duke implemented a diversity hiring pattern more aggressively than most elite institutions, largely under the leadership of Chafe and the previous Duke president, Nan Kahane. And you could argue that the undergraduate faculty at Duke today is very similar to what the undergraduate faculty will look like at most elite institutions in 5 or 10 years down the road in terms of pedagogical and intellectual interests. The Duke administration, headed by Richard Broadhead might be many things, but I don't think you could argue that he is more extreme ideologue than, say, the current presidents of Harvard or Princeton or Penn. So this was not a case where you had an administration that was very much to the left of its faculty driving things. I wanted to conclude with a vignette, and then hopefully we can take some questions or discussions. And it's a story about one of the most moderate members of the Group of 88, a history professor named Susan Thorne. Thorne is a specialist in British and women's history. Unlike many members of the group, who it's quite clear despised at least a portion of their students who fell on the wrong side of the race, class, gender, or athletic status divide, Thorne did not. Thorne had taught many of the lacrosse players over the previous decade. One of the captains of the lacrosse team, a kid named Danny Flannery, whose parents are both CUNY professors, not exactly the image of an upper-class bastion, had looked upon Thorne as his intellectual mentor at Duke. He had taken a couple of courses from her. He had developed a very close relationship with both her and her family. He was stunned when he saw her name on the initial Group of 88's ad. In the fall, this continued to bother him. He had graduated from Duke at that point. And he decided to email Thorne and ask her how it was that she could have signed the ad. And she wrote back in a lengthy email exchange that went over the course of the fall and admitted that she felt terrible about what she had done. She recognized that she had rushed to judgment. She apologized to Flannery in writing. And she asked what she could do to make it up. And so Flannery asked her, this was before Nifong had recused himself from the case, had asked her if she would be willing to publish an op-ed in the Durham or the Raleigh newspaper, apologizing for her rush to judgment and urging people to look at the facts of the case dispassionately. And Thorne promised him that, in fact, she would do so. She even wrote up a draft op-ed, which she sent to him. The next that Flannery heard from Susan Thorne was when he saw her signature on the clarifying statement letter, which included the following line. There have been calls for the signatories to the Group of 88 to apologize. We reject all of these calls. Flannery emailed Thorne and asked her, you've said you're going to apologize, you've even given me a draft. How is it that you could possibly not only not apologize, but then sign this statement saying that you were going to refuse to apologize? And Thorne wrote back a quite cold, but probably correct assessment. She said that she had given the matter considerable thought, and that she had decided that she had no choice but to sign the clarifying statement and not to issue her promised apology, because unless she did so, and this is a direct quote, my voice won't count for much in my world. And it seems to me that it's worth asking, even though people at Duke seem unwilling to do so, what kind of academic culture it is that exists on contemporary campuses in which a clearly well-meaning professor, Thorne wanted to do the right thing, could conclude that and could correctly conclude that the only way that she could retain a voice with her colleagues is to publicly betray her students not once, but twice. And that, it seems to me, is the most depressing of the lessons of the Duke Lacrosse case. And while I doubt very much that we're going to see a prosecutor who is at least as blatantly dumb in terms of misconduct as Nifong was, I fear that we are going to see similar instances of faculty who look upon their students as the enemy, and who are willing to betray not only the Academy's evaluation support for due process, but, like Susan Thorne, willing to even betray their personal relationship with their students in order to advance the diversity approach, which is so much valued on today's college campuses. So I'd be happy to take questions or comments.
My name is Dan Subhan. I teach at Touro. A couple of things. First of all, it is statistically highly improbable that the rape took place as charged. If you look at studies by the Department of Justice, you find no, and I mean no, instances. That is to say, of course, it's rounded off, so there got to be some instances of white on black rape. So, and that tells you something about the academic culture. I published an article actually, which this summer in the University of Southern California Law Review, Journal of Law, I don't know, whatever it is. It's called Hands Off, Sex, Feminism, Affirmative Consent, and the Law of Foreplay. And this case, and one at Brown, which you may or may not be familiar with, which I am familiar with, really frame the whole issue. And I try to tie the Duke case to Susan Brown Miller and the whole movement against rape. Not that I'm in favor of rape, but I am in favor of honest discussion, and the discussion has been false from day one. There is no rape problem on campus at Duke, although the letter suggests otherwise. The ad, that is, suggests otherwise. What was the other thing I was going to say? There is a high. The rape problem in America is less than at many, and maybe even most, industrial countries. That was not the case 15, 20 years ago. And let's see, one more thing. I can't. Let's see. All right, and I just can't. I had something else I wanted to say. So there was never a problem to speak of, and the slightest, and the first opportunity to use this for political purpose was swallowed whole. I've looked at your book, and I've read most of it, but it's the academic culture part of that is so fearsome. I know what it was now. There are data showing that there is a much higher rate of false rape reports than any other crime. Not surprising, and yet the official position of all the women who write in this area is that the false rape rate is 2%, which is apparently the false accusation rate for other crimes. There are some fascinating studies here, terrifying, fascinating. One major study, in fact, the only major study by a psychologist at the University of Indiana, who's retired now, showed that 41% of the claims of rape were proved to be false rape. So this is an area in which people are emotionally invested to the point where they can't see straight. And I think you're describing the problem that arose as a result thereof.
Right. I mean, a couple of interesting things, I think, about the case on these issues. There was another allegation of rape at Duke this past February. It involved a party at an African-American fraternity. The allegation was that a black male who attended the party raped a white Duke freshman. There were witnesses to the alleged rape. There was an arrest that was ultimately made. The procedures were appropriately followed by Duke. There is no record of any Duke professors, even one, publicly commenting on this rape. There is a Duke administrator, Dean of Student Life, Larry Mineta, who did issue a comment saying that this episode shows the need to learn life's lessons, and perhaps the Duke's female student won't put herself in such situations in the future. It was a remarkable statement. On this question of the alleged rape problem at Duke or any place else, Duke, the judicial University Judicial Board keeps statistics. There's been a lot of controversy about Duke, but really about universities wide. Think of Fire or Alan Core's and Harvey Silverglate's work on this issue. I mean, the university judicial system is a guilt-presuming system where you're guilty until proven innocent, and then maybe even not innocent then. And yet, the statistics suggest that there are almost no reports of sexual assault at Duke within this system. And what was remarkable about these statistics is that this was the only crime where a majority of the cases, the person who was charged got off. So even under what was a very flexible interpretation of sexual assault, and in a judicial system that is guilt-presuming, there weren't convictions. And I did the statistics in one blog post. It was something like 0.015% of Duke students had, and made such a claim. So yes, it's a serious problem. And finally, on the question of false rape reports, one figure who has not gotten a lot of attention from the media, she got a good deal of attention in the blog, was the sane nurse in this case, a woman named Tara Levicy, who is one of, in some ways, is a more frightening figure than Nifong. Nifong, in the bar hearing, Lane Williamson argued that Nifong was guilty of self-deception born out of self-interest, and I think that was an accurate description. Nifong, in his mind, had convinced himself that there was a rape, and there was no evidence that could convince him otherwise. Levicy was simply an ideologue. In interviews with defense attorneys, she said that she believed women never lied about rape. And her job in this was an expert. She had interviewed Mangum on the night of March 14th. She simply took Mangum's story. And yet 3 times over the course of the case, Levicy's version of what Mangum told her on that night dramatically changed. And each time it was changed in such a way to substantiate the prosecution's new and radically altered theory of the crime. Levicy was subsequently removed from Duke Hospital. It's unclear whether she was fired or voluntarily resigned. She's now in New Hampshire working as a sane nurse. But the kind of group of people who even in this case could not believe that there was a false claim of rape from either victim's rights standpoint or a sane nurse standpoint is really quite frightening, yes.
Would you comment on the New York Times?
Yes. The Times coverage of this case, I should confess I had biases coming in. I read the New York Times daily. I recognized the criticism of the Times, but I assumed that the Times was at least factually accurate and would correct errors of fact. That did not happen in this case. There were a couple of things that came together, I think, to explain the Times coverage, which was wildly slanted and frighteningly slanted in Nifong's favor. What I think was the most disturbing aspect of the slant is that the slant only became apparent the more you knew about the case. And so, for someone like me, I was given access to the entire discovery file very early on under the condition that I could not reveal anything that was in the file. So I knew that the Times was mischaracterizing the discovery file in what was their major story in the summer of 2006. It was very disturbing. I think that the two things that came together, the first was the decision to treat this initially as a sports story. This was it was really not ever a sports story, and if it was a sports story, it was a sports story for around 2 days. The Times' primary reporter on the case was a sports reporter named Duff Wilson, who, well after it was clear that he was at least incompetent and at worst incredibly slanted, was not removed from the case. The sports columnists, especially Selena Roberts and Harvey Araton, used this case to presume guilt from the start. It fit their agendas. As the case went on, it seemed to me that what occurred was that the Times was unwilling to admit that it had made a mistake, and assumed that there was going to be a trial. So everything, their coverage was sort of built under this assumption, and so bad things would come out about the lacrosse players then that would justify the original coverage. Of course, there wasn't a trial, so the Times got stuck. The strangest vignette about the Times coverage came the day after the August 25th, 2006 story, which is the major Times story. It's a 5,600 word story on page 1 that stated that there was evidence in the discovery file that justified Nifong's decision to take this case to a jury. That statement was disproved by the Attorney General, who said that there was no such evidence. The day after that article appeared, Duff Wilson was the reporter, emailed Brad Bannon, one of the defense attorneys, and asked Bannon if he would send him a full copy of the discovery file. Well, that article had stated that Wilson had already thoroughly reviewed the 1,850 pages of the discovery file. And it was perfectly clear that Wilson had not reviewed anything in the discovery file apart from maybe 10 or 15 pages that Nifong had handed over to him. And one easy example of this, the only evidence that was against two of the guys, Reed Seligman and Colin Finnerty, was this flawed April 4th, 2006 lineup, which was confined to the lacrosse players. In that lineup, Mangum did correctly identify one of the players, Dan Flannery, the captain, as having given her money. He was the person who had paid her. He was the person who had hired her. He was the captain. That was the only correct identification that she made. She did state in that lineup that she was absolutely certain that she saw this kid named Brad Ross at the party. He was out in the front porch chatting with the second dancer. Brad Ross, the evening of the party, was in Raleigh, North Carolina. You would think this would have caused doubts. It appears as if Wilson was not given the full transcript that showed which player was identified. The transcript that had been publicly released at this point simply identified the players by numbers, 1, 2, 3, 4, 5, but it didn't give a match to each of the numbers. So he assumed that all of Mangum's identifications of the non-suspects, I saw player X drinking in the kitchen, were correct because Nifong told him this, and there was this one evidence of a correct identification. So in the article, Wilson describes this lineup as a remarkable performance by Mangum in her ability to correctly recollect what she had seen 3 weeks before. If he had seen the full discovery file, there was just no way he could make that sort of claim. It made absolutely no sense. Last point on the Wilson article, there were 4 errors, out-and-out errors of fact in the Wilson article. All 4 of these errors of fact slanted the case in Nifong's favor. All 4 of these errors of fact were brought to the attention of people very high up at the Times, not only by me, but by the defense attorneys. To date, the Times has refused to run corrections on 3 of them, and on the 4th, they ran a correction that made it more confusing and only compounded the error.
Well, thanks again, Casey, for all your heroic work in this case. Those of us who followed the case through you really admire and are appreciative of what you've done. My question is about I'm sure you've had an opportunity to give thought to institutional reforms that might address the problems of prosecutorial misconduct. As I mentioned to you earlier, I'm a former prosecutor myself, state court criminal prosecutor. I'm very familiar with the faults and foibles of the prosecutor's offices, although I'm pretty pro prosecutor as a cultural matter. There does seem to be a psychological phenomenon that happens, and I can't explain it, and not everybody experiences it, but I've witnessed it, where having been committed to a theory of a case, a paradigm, so to speak, in a Kuhnian sense, all contradictory evidence is then interpreted away. And I'm not exactly sure what it is about the psychology of being an advocate or being a prosecutor in particular leads to this, but I've noticed it in notorious cases in Illinois that I was familiar with after I was a prosecutor. So on the other hand, we have the system we have. We have public prosecutors, which I think by and large, I mean, in this case even shows how they are politically accountable, can be made politically accountable. And I'm just wondering what ideas you've come up with that are sort of realistic reforms that could actually change things for a future case such as this.
One of the ironies about this case is that North Carolina had actually been quite progressive on broad due process reforms, and because they had the case, I think, resolved the way it did, the key figure in this was Beverly Lake, who was a conservative Republican, the former Chief Justice of the North Carolina Supreme Court, become very interested in issues of actual innocence, had established an innocence commission. Through his efforts, the state had passed, and I believe there's only one other state that has a law of this extent, full open file discovery statute was passed in 2004. Without open file discovery, Nifong simply wouldn't have turned over the transcript, say, of the lineup session. He wouldn't have turned over the underlying DNA data, and he probably would have gotten away with at least some of what he did. In his ethics trial, he called as one of his witnesses, and one of the strangest things of the trial, the former DA of Durham County, who had been there when Nifong started, this guy named Anthony Brannon. And Brannon said that he missed the old days. He said when he was a prosecutor, he preferred actually to withhold as much evidence as he possibly could from the defense. He was very distressed that North Carolina had moved to open file discovery. How this helped Nifong retain his bar license was not entirely clear. So I think one of the lessons of this case is that open file discovery does in fact work, and that because of this question of that even prosecutors in very good faith might not be able to identify exculpatory evidence. It's better simply to require everything that be turned over. The other, I think, major procedural reform that comes from this case, and again, North Carolina had pretty good procedures. The state legislature actually intervened and mandated this after the Lacrosse case, is to be much more due process friendly in either lineups or photo ID sessions, to ensure that there are filler photos, to ensure that these are videotaped. This is now the law in North Carolina, to ensure that they're run in such a way that the person doing the investigation doesn't have subtly influence the policy. So these are, I think, two doable reforms. No honest prosecutor could oppose such reforms that are positive legacies from the case. The third possible legacy is that this was a case with very few heroes, but one of the heroes was Lane Williamson, the chair of the Disciplinary Commission, and more broadly the State Bar. And the State Bar's willingness to intervene in this case, it was a very risky maneuver. The vote was in the grievance committee was 8-8 to charge Nifong with ethics violations immediately, rather than to do a sealed charge that would end the trial to occur after the Lacrosse case had been tried. The 8-8 tiebreak tie-breaking vote was cast by the chair of the grievance committee, and I think this case does prevent a model of how the bar can act, at least in extreme cases of prosecutorial misconduct, and other state bars might be more willing to step in, seeing what happened in North Carolina. But the two due process reforms that hopefully I think everyone in this case involved in the case will support are the, open file discovery and tightening procedural restrictions on lineups.
Yes,
Yes. Well, one question I have about you looked at various parts of the university's institution. One group of people you haven't mentioned are the Board of Trustees. Certainly in a corporation, if this had a variety of events had occurred, I think the Board of Directors would insist on some outside investigation. And so I'm wondering what the role, if any, of the trustees was, and did you try to talk to them?
This was a mystery for me. I've worked at CUNY. I've worked very closely with some members of the CUNY Board of Trustees. We have an excellent Board of Trustees and a few, particularly Jeff Weisenfeld, Benno Schmidt, who are quite active and have been positive forces. I had assumed that there would be a similar thing at Duke. That did not occur. It didn't occur, I think, for a couple of reasons. Duke has a very large board. It's a 37-member board. 24 of the 37 are elected by two Methodist denominations that helped found Duke. The power in the board essentially resides solely with the chairman of the board. Chairman of the board at Duke was a guy named Bob Steele, who is currently Undersecretary of the Treasury. He is everything that the Group of 88 would despise in American society. Former Goldman Sachs vice president, a multimillionaire many times over, a clearly conservative Republican, someone you would not have expected to have gone along with the Group of 88's crusade. Steele, however, had been the key figure to select the current president, Dick Broadhead, which was a controversial choice. Broadhead had been dean of faculty at Yale. Those of you who follow Ivy League sports know that Yale sports is just a little different than Duke sports is. It was an odd choice, and Broadhead, he's clearly out of his league as Duke president. And so for Steele, this case was a very personal one. And it was personal because it had to show that he had made the correct choice as president of Duke. He made mistakes that I thought were inexplicable. Were inexplicable. For instance, he issued an email to the other 36 members of the Board of Trustees saying that he and Broadhead had been in close contact with the families of the three falsely accused players. In fact, between the arrest of Reed Seligman and December 22nd, 2006, when Nifong dropped the rape charges, there was only one person in contact from Duke with the Seligman family. That was Larry Mineta, who sent Seligman a letter saying that he could not come onto the Duke campus unless he informed the police. There had been no contact. The Seligmans were very, very angry. This was one of the reasons why they sued Duke. Why, if you're the chairman of the board, you would issue a statement like that, which is a demonstrably false statement and is easily proven to be demonstrably false, is not clear. Steele also had a tendency to sort of run off at the mouth. Broadhead had said he canceled the lacrosse season as a way of punishing the players for the party and for protecting them from possible violence. Steele gave an interview in October of 2006 to the New Yorker saying that the real reason the 2006 season had been canceled was PR, that Duke couldn't afford to have photographs of the lacrosse players practicing. That obviously was the real reason, but you can't say that publicly. So this was a case, I think, of basically incompetent leadership from the trustees. And trustees are such an important balance. I mean, to the extent that we have academic groupthink, which is a real problem, we need active trustees to balance at least some of the worst excesses of the faculty. And in this case, for very different reasons, we had the trustees who were willing to go along with the faculty.
Yeah, I'm interested in first, was there any short-term effect on Duke in terms of admissions or money? Did you see anything like that? And then secondly, you said you expect in 10 years' time other departments to model, that Duke was aggressive with the sort of postmodern diversity in the humanities. Why isn't this the case to swing the pendulum back? This is, everything you say is just so awful. Why isn't this the case that's going to have some backlash against that?
On the first question, there was some shift. It's unclear whether the shift is going to be permanent. The Duke did not suffer in terms of the number of applications. It actually had the second highest number of applications in the history of the university for the class of 2011. The demographics, however, of the admission class dramatically changed. There was a plummeting of white Northeasterners who accepted admission to Duke. And if you were the parent of a white Northeasterner, you might understand why you would not want to send your son or daughter to Duke. A dramatic increase in African American and Hispanic admittees. In terms of fundraising, Duke has been, opaque would be too generous a word to describe what they've done here. There has been no discernible change in fundraising. However, it appears that what has happened is that large foundations, especially the Duke Foundation, dramatically increased their donations to Duke in the past year to compensate for what appeared to have been a dramatic decrease in donations, especially among parents of current Duke students. It was a drop from 41% of the 2005 Duke donor pool came from parents. This most recent one was only 17%. That's a very sharp decline. So whether these are permanent changes, though, or a kind of temporary reaction, I think is unclear. My guess, especially with the donations, is that in part it's going to be a temporary one because 4 years down the road you'll have parents who have had no response to this. In terms of the future, yes. I mean, you would think in a logical world there would be a reaction and a backlash against this. But the Academy is many things. It is not logical. There is no evidence that I've seen of even one administration from an elite university that has used the Duke case to reconsider the wisdom of diversity hiring patterns. And what Duke is doing is really, what Duke did is really a model here. Obviously you can't have quotas in terms of hiring patterns. So what Duke did was to dramatically redesign pedagogically in the hopes of attracting a diverse pool. I mean, you're more likely to get, if your goal is to get a black lesbian, you're more likely to get that if you advertise in black lesbian literature than you are in, say, biochemistry. So essentially what Duke did is achieve a more diverse faculty. It's clear they have a more diverse faculty now than they did 15 years ago, at the expense of this pedagogical shift in the humanities and social sciences department. Logically, you would see other administrations who would say there's a real downside to this. What you get are, a very extreme faculty, and particularly, and I think the really troubling aspect of the Duke case is a faculty that see at least some of their students as the enemy simply because of the student's race or gender or athletic status, and that's a real problem. But I've seen no evidence that administrators elsewhere have taken that kind of lesson from Duke, and clearly the Duke administrators haven't.
Thank you very much. Two short questions, and perhaps Professor Barnett answered the first already. Why were there no whistleblowers in Naifang's office, right? And then the second question would be, what's the status of the litigation against Duke and the professors? Thank you. The question of why there weren't whistleblowers in Naifang's office is a disturbing one. A fairly strong case could be made that at least two of the assistant district attorneys in his office also committed ethics violations because they were involved in minor ways in the case. Part of the problem, I think, is a structural problem in North Carolina. DAs have basically absolute hiring and firing power. There are very few protections. And the demographics of the Durham DA's office are particularly interesting in this regard. Durham is not an area of choice if you're going to be an assistant DA. So it was a DA's office under Naifang's leadership, with Naifang, who was like in his mid-50s, who had been there for 27 years, two other fairly senior people, and almost all the rest were under 35 or so. So people who were there for 3 years and then were going to move on. And so for most of them, their goal was they didn't want the bother that, of filing an ethics complaint against a DA, given that they were going to be out on the job market in a couple years anyway. Their institutional loyalty was to themselves. It was particularly striking. A former assistant district attorney, Kendra Montgomery Blinn, who is now head of the North Carolina Actual Innocence Commission, testified in Nifong's favor at his ethics trial, which was astonishing, and said that in her opinion he had handled the case appropriately. So yes, there should have been people who have stood up, but there were not. The second question. Oh, the status. Yes, the three falsely accused players sued Duke and received a settlement that was widely rumored to be between $17 and $19 million. That the amount was never publicly revealed. Three other unindicted players have sued Duke. The other 40 unindicted players may sue Duke. That's an uncertain question now, but it looks as if they're going to. The three falsely accused players have also sued the city of Durham and the DNA company. The city of Durham rejected the settlement offer, which was $30 million. It is very likely, I think, that Durham will settle. The depositions in the state bar proceeding against Nifong were very limited in terms of interviewing Durham police officers, and they were unbelievably damning. The head cop in the case, a guy named Mark Gottlieb, produced this pristine 33-page typewritten memorandum 4 months after the interviews that actually took place, that filled in all kinds of holes in Nifong's case. It was manufactured evidence. In the depositions to the state bar, he was asked, well, where were his contemporaneous notes? And his claim was that he had kept contemporaneous notes on an eraser board in his office, and they had all been accidentally erased. That's not the sort of thing that you want to go to trial with if you're the city of Durham. So my sense is that Durham will settle. They didn't settle now because there was an election in Durham in 2007. Duke also settled with one family of an unindicted player for grade retaliation in what was the most obvious case of grade retaliation I've ever seen. It was a professor who wrote that the lacrosse players were in her class were unindicted co-conspirators to the rape, and then gave both of them F. Duke settled. So yeah, Duke is still going to be paying out more money.
Last question.
About 55 years ago, in the precursor to what has gone on in the McCarthy era, McCarthy was harassing a witness at one of his hearings. And the lawyer, in what is now a well-known line, stood up and said, "Have you no shame?" Where is that person now? Where is that person not only on the Board of Trustees? Where is that person in the law faculty on Duke that should be particularly attuned to this? Where is that person among the Alumni Association? Simply suing Duke isn't going to get it done because it's just institutional money. These foundations will provide it. And it wasn't per se the institution. It was deliberate decisions by individuals, by rotten apples in the barrel, that made this whole thing possible. Nifong has been held accountable. He lost his job. He was disbarred. He went to jail for a day, and he's going to lose everything he owns in a civil suit. But these academic hoodlums have not been held accountable. As you point out, this is a vision of the future, and it's a future that bodes ill, not just for academic freedom and the pursuit of truth, but for innocent individuals. Who is going to stand up and say, "Have you no shame"?
Yeah, there are aspects of this case that I think are, in some ways encouraging. I mean, the question that Randy Barnett was raising, that you do see procedural reforms that could come out of this case that will protect innocent people who are falsely charged in the future. But the academic side of this case is depressing. The only person at Duke who I think has made this kind of have you no shame kind of statement is Jay Billis, former Duke basketball player, Duke law graduate, and a very influential Duke alumni who did a powerful letter demanding that Broadhead and Steele both be fired. He submitted it to Duke Magazine. They refused to run it. They put it on their website instead. The only voice in the law school faculty during the case was a professor named Jim Coleman, former chief counsel to the House Ethics Committee when the Democrats were in charge in the early 90s, liberal African-American, who stood up and was very courageous in criticizing Nifong. As soon as Nifong was disbarred, Coleman flipped on a dime to criticize people like me, who, and I had a very good relationship with Coleman during the case, who were criticizing the Duke faculty. And so the person who was really the voice of moral power in this case, Coleman has retrenched entirely. And Coleman's new theory is that people who have criticized the performance of the Duke faculty have deliberately refused and distorted the record because he claims conservatives were actually more critical of the lacrosse players than the far left. There's no evidence of that. It's simply an out-and-out lie. And so I think that there really is, there's nothing on the case at Duke. People who are at Duke who are asking this. Erwin Chemerinsky, who had his own difficulties with academic freedom in recent months, repeatedly told the mother of one of the lacrosse players that he was going to stand up for due process in this case when the time was appropriate. And he was just never able to find an appropriate time to stand up. And so I would agree. I think this to me, this is the most troubling aspect of the case. It's not that there was the rush to judgment, which is troubling in and of itself, but that there seems to be this incredible unwillingness to recognize that this was a horrific injustice, incredibly bad behavior among the faculty, which leads you to believe that it's going to occur again, and it's going to occur in cases that aren't like the lacrosse case that get a lot of publicity, cases that most people don't even notice. Thank you again.